Okay, we'll get started. Probably some people will join us in the next couple of minutes, but I'll keep to time so we can get through it all. Welcome to the webinar for the end of March, beginning of April. It's now already the 6th of April or something, so we're already in April. Can you believe it? This time we're going to be talking about recruitment processes, things to think about in terms of what recruitment we're using, how we're using it, how we're using information that might be given to us during that recruitment process, and also how we deal with information of people who don't necessarily become employees of ours, and we might retain some information from them as well. And also different tools organisations might use for recruitment and how that might get us into some trouble and how we mitigate those risks. So that's what we're going to be talking about today. As always, if you have questions throughout, please just unmute yourself and ask the question. I'm not precious about waiting till the end or anything like that. But of course, if you want to wait till the end, happy to do that as well. And we should have some time at the end to go through those questions that you might have. If everyone can just check that they're on mute, I think I can hear someone just so that everyone can hear me, hopefully. So in terms of what we're going to be talking about today, we're going to look at job advertisements. So things to think about when we're writing job advertisements. And things that we might, not necessarily think about when we're putting them into the advertisement, but again, might cause us some issues. And again, thinking about who might be writing the job advertisement. So it might not necessarily be the HR person who's writing that, who will have an idea of what to include and what not to include, and questions we might ask and things like that. We'll also look at recruiters, the use of recruitment and recruiters in terms of agencies. A lot of organisations use recruiters these days to headhunt for talent and things like that. And as I said in the email that went out, basically everyone I'm talking to is saying about how they're looking for talent and getting talent is difficult. So I think everyone is on the hunt for that talent and competing against one another. And it's about things we might say or things that the recruiter might say to those potential candidates about the job and what it is and how it works and the organisation that might get us into some trouble. And I've got some examples about that. We'll also talk about interviewing and what you can and can't ask. Again, pretty simple things probably for most of us attending today, but what I'm finding again is that it's not necessarily those who have a HR expertise or are pretty akin to things that you can and can't ask in recruitment interviews. It's more probably your managers and things like that who might be conducting interviews or doing second round interviews. And things that might come up in those interviews and how we deal with that as well. We'll talk about that. We'll also talk about social media in recruitment. So again, for example, getting a resume that comes in and jumping onto Facebook or LinkedIn and looking at that person and some things to think about if that's something that we might be doing. And then finally, how we can best protect ourselves from a decision-making point of view in terms of documents we might keep, notes we might record, and how best to mitigate risks of a discrimination claim or something like that. Now, from a recruitment perspective, the most common types of claims that you probably see are discrimination claims or general protections claims, which we'll touch on towards the end of the webinar. So those are the types of claims that you will generally see. So someone might say, oh, you didn't select me because I'm female, or you didn't select me because of my age, something like that. Those are generally the types of claims that we'll see. And the other common claim that you might see, which again we'll talk about from a case example, is statements that are made about the nature of the employment and the employee relying on those statements and accepting the job on that basis. And then it turns out that what we've actually said is not correct. And so that's basically what courts will say is that's misleading and deceptive in terms of what you've told that employee. So again, thinking about how we might mitigate those risks. I do have quite a few cases that we'll talk through today. I think it's a good way to illustrate how things might go wrong. So I will read some passages from some cases just because I think it's really beneficial to learn from other people's mistakes, and also have a look at what the court is saying about these things so that we can get a really good idea of how to best navigate recruitment. So in that recruitment type context, the things to think about are your job advertisements and those pre-employment discussions. And as I was saying, the kinds of things that come up generally from those job advertisements or those pre-employment discussions, so those discussions that your recruiter might be having or that you might be having with an employee before they sign on the dotted line, can give rise to those misleading and deceptive conduct type claims. So that example that I was giving about how they've been told about a job, and we'll talk about a particular case, O'Neill and Medical Benefits Fund, where this employee was basically enticed to come across to Medical Benefits Fund by a recruiter, and that was held to be a breach of the misleading and deceptive conduct provisions, which we now find in the Competition and Consumer Act, which is a bit of a weird act to kind of think about from an employment perspective. Competition and Consumer Act, you usually think about, refunds and exchanges and your rights and protections as a consumer, but it does have provisions that deal specifically with employment. So we'll have a look at that. And as I said, discrimination as well. So discussions that you might have during those phases when you're interviewing employees, and comments that might be made. We'll also, as I said, talk about conducting the interviews and also your interview notes. So things that you might jot down or people might jot down that, they don't really think about but might have a potential impact on us later. And so to give you an example, if you had someone conducting an interview, the person is just generally having a chit chat at the beginning of the interview, and they say, oh, I've got 2 kids, I'm divorced and I'm 54 or whatever it is. If that person conducting the interview or people conducting the interview write that down on the interview notes, it's not relevant to the job, likely, or the inherent requirements of the role. But just say the person doesn't get that job, if those interview notes have to be produced, then a question might be asked, well, why did you write those down? And if they're saying, for example, it's age discrimination, well, you've written down 54. So they might say, well, I think that's a reason that I didn't get the job. So again, it's about thinking about how what we take down or what notes we write or the information that we collect, how that might be used in potential claims. And then thinking about employee screening. So I know a lot of organisations use methods of employee screening, so conducting pre-employment medical checks or asking about criminal records, things like that. And again, thinking about how that operates in practice. Generally, what I would say is that those pre-employment medicals or the criminal record checks generally have to be relevant to the role. So think about, for example, if you in the construction industry and you have an employee that's going to have a very labour intensive role, then you probably will perform a pre-employment medical, or you may require an employee to go to a pre-employment medical to check, they don't have any back issues. That means they can't move a certain amount of kilos or things like that. And same as criminal records. So you might work in an industry or an organisation where they have to have a clear criminal record, or you go to clients that require no criminal record, things like that. So again, thinking about, are we just applying that across the board? And does that create risks for us in terms of, so if a receptionist is asked to go and do a pre-employment medical, is that really reasonable, and does it give us any indication that she can or can't perform the inherent requirements of the role? What are those requirements? And then if we are sending them for that employee screening, again, making sure that we're using that information to assess only whether they can perform the inherent requirements of the job and not using it inappropriately that might give rise to a discrimination claim, particularly because that's usually identifying health issues, physical or mental health issues. So if we look at job advertisements, first of all, thinking about how we go about drafting those, and I was giving a conference a couple of weeks ago, and that group also raised some things that I think are happening in terms of websites you might use like Seek to advertise for roles, and questions or boxes that they might say should be included in the job advertisement. So I thought I would touch on that. So obviously in a job advertisement, drafting is key. So we want to avoid requirements that could be discriminatory. And we really need to think about, well, what are the inherent requirements of the role? So we don't want to necessarily be saying this is a full-time role if that is not an inherent requirement of the role, because what an prospective employee might allege is that you're discriminating against me because of my family or carers' responsibilities. And I'm not saying that there aren't roles that inherently need to be full-time. But just thinking about the wording that you're using in those job advertisements, and really is what you're putting in that job advertisement an inherent requirement of the role. And thinking about the language that we're using in those advertisements. And so, as I said, in that conference I was giving, one of the things that came up is that I think in Seek at the moment, you can ask, or it's automatic perhaps at the moment, around vaccination status for COVID, and whether they are vaccinated or not. And again, thinking about that from a discriminatory point of view. So the question firstly is, okay, are they required to be vaccinated? Either we've got a policy that we want mandatory vaccinations and we say that that's something we require from a work health and safety perspective generally, or there's a public health order that says employees need to be vaccinated, so we might be in an industry where that's an inherent requirement of the role. So again, a lot of organisations use those pre-populated forms and things like Seek and other online job advertisement platforms, and just thinking about not just going through the motions in terms of filling out that form, thinking about, okay, what's the role that we need? Is what I'm putting in the role potentially going to be discriminatory? Another one that came up for me a few years ago now, but it was an interesting point that an employee was making in terms of, sorry, I think someone's not on mute. So if you can just check that you're on mute. In a claim that I was dealing with, the prospective employee had applied for a role, and they had applied and were unsuccessful. And they brought a claim of a number of other things, but one of the things was age discrimination. And they were saying that the organisation had potentially discriminated against them because of the way they had advertised the role. And the prospective employee was asserting that they had only advertised the role online, on the internet, using Seek or whatever it was, the platform. And they were saying that that potentially was age discrimination because, and as I said, this is a few years ago now, because people older than, they were basically saying people older than 50 wouldn't necessarily go online to look for a job. And so there should have been other ways that that role was advertised in terms of the newspaper or something like that. And so they were trying to run an age discrimination claim in relation to the way that we had advertised the role. And so I think these days most people will advertise online, and I'm not sure that that would give rise to an age discrimination claim. But it's just, again, something to think about in terms of how are we making the job available? What are we doing in terms of trying to recruit and those recruitment tools that we're using? And I'll actually talk about another example a bit later on involving McDonald's and a mechanism there they were using to recruit employees. And again, a question around whether that gives rise to potential age discrimination. And then obviously in the job advertisement, we don't want to be making representations that are misleading and deceptive. So we don't want to be saying this is going to be a job that you'll have for 5 years, or we guarantee employment for 10 years or anything like that. Now, I don't think anyone's going to be doing that, particularly in job advertisements, but it's certainly something that might be said by recruiters or in pre-employment interviews, so in discussions that we're having with the employee. So we need to make sure that any representations that we're making to the employee or prospective employee are honest and accurate. So to give you an example, another thing that's come up previously in cases is a question around bonuses. So an employee was looking to move to this organisation and representations were made about the extent of the bonus they would get in those circumstances. And the employee was actually taking a pay cut to move to this new role, but had factored in the bonus that was represented to them that they were able to achieve. And then what actually turned out happening is that the organisation didn't do as well financially in that next year, and the bonus wasn't at that level that was represented to the prospective employee. And the people that made the representation at the time had an idea that their financial year wasn't going to be as good as it had been. And so those representations were found to be misleading in terms of what was discussed. So again, thinking about, and again, you're not probably going to put in a job advertisement, you're going to earn 50,000 in bonuses or things like that, but it's just thinking about those things and things that you might think are kind of benign in terms of a job advertisement, thinking about really what do we need to say in that advertisement, and making sure that we're not giving rise or creating issues for ourselves down the track. As I mentioned, a lot of employers, I think, are now requesting information about the vaccination status of employees. And I just wanted to remind you that generally the vaccination information, if you're collecting that information, it's sensitive health information, and then there's privacy obligations under the Privacy Act for those that are covered. So think about whether we actually need that information or whether we just want to cite that information. So rather than collecting and storing it as a record, do we just want to cite it and then that's it, and we don't actually hold that as a record? But even if you just tick that someone has been vaccinated, that will generally be the collection of that information. So think about how you store that. And particularly if, like I said, they don't actually become an employee, then you have those privacy obligations if you do store that information. Once they become an employee, there's an employee records exemption in the legislation. And I'll just note that that is currently under discussion in terms of whether that employee record exemption will continue. So what the Privacy Act says at the moment is that if the information falls into an employee record or meets the definition of an employee record, then you don't need to comply with the privacy obligations. But that's only once they have that employment status and once the information's been collected, is what the case law generally says. So those prospective employees that you don't end up hiring and you might retain some information about them, you need to comply with those privacy obligations. And that vaccination information is held to a higher status. So that's that sensitive health information. And generally you have to have a clear and justifiable reason for collecting that information. So as I said, that will go back to your vaccination policies. And if you say from a work health and safety perspective, we say that that's how we minimise the risk as best as reasonably practicable. And that's why we require that. Or the public health order says you need to be vaccinated, something like that. But just think about how we store that information. And my general view to clients is, even though we have that employee records exemption, once we've collected the information, I still would encourage you to treat it in accordance with the privacy legislation as best you can, because not everyone should be having access to that information, I don't think, in general, and only, you know, your HR people or the people that need to know should be having that information if you do decide to collect it. So I would probably err on the side of caution and treat it with as if it was that sensitive information. The employee record exemption doesn't apply. And as I said, that is something that's being looked at to see whether it's something that should continue in the legislation or whether all employers should be bound by those privacy obligations in terms of how they treat that information. So this is an example of a case involving Woolworths. As you can see, it's from 2014, and Woolworths has since changed its recruitment practices around these questions that were being asked. But I think it's a good example of kind of things that we might think are not an issue in terms of questions that we're asking or reasons why we're asking the questions, and what, in this case, the tribunal said around the questions that were being asked. So this was in Queensland. So this was under the Queensland Anti-Discrimination Act. And so what happened in this case is that the applicant was applying for a role at the Woolworths petrol station. And to apply for that role, they had to fill out mandatory fields in that online recruitment system that Woolworths had. And that included giving your date of birth, your sex, so your gender, and uploading documents that evidenced your right to work in Australia. So a copy of your passport or your visa, things like that. And they couldn't proceed with the application unless they provided that information. So they were mandatory fields. They weren't, this is optional or anything like that. And what the tribunal found in this case was that the applicant had been discriminated against, or that Woolworths was engaging in discrimination by requiring prospective employees or applicants to provide their date of birth, their gender, and their proof of right to work in Australia. And so basically in this case, what happened is that Woolworths was saying, well, we require this information. So on the age point, they were saying that we want to know someone's age or date of birth because it could determine what rate of pay we have to pay them, because employees under the age of 21, for example, are paid at a different rate and come under a different enterprise agreement. So Woolworths had a lot of enterprise agreements, as opposed to an employee over 21. And so we wanted to know their date of birth to establish, okay, well, what rate of pay do we have to pay them? They also said they had about 190,000 employees, and so getting the date of birth was a way of differentiating employees with the same name. So if you had John Smith, for example, we had John Smith born in 1975 and John Smith born in 1995. So it was a way of differentiating between those employees. And also they were saying that some of the positions that they recruit for, the employee had to be over the age of 18. So for example, BWS is an organisation that's owned by Woolworths. And so they said in those circumstances, we couldn't obviously employ someone that wasn't over the age of 18 to work at BWS. So that's why we needed that age information. In relation to gender, so this was at a time where the Workplace Gender Equality Act was being contemplated, and so they were anticipating that they might have to report on gender recruitment. But again, it wasn't something that was actually in place at the time in terms of that requirement. And for the right to work, again, they were saying under the Migration Act, it's unlawful for us to have workers who don't have a legal right to work in Australia. So we want to know that information. And what the tribunal said is, okay, we understand that the age might be a relevant consideration, but they said a simple question on the form asking, are you over 18, would suffice in terms of, okay, can they perform the role at BWS or not? And they said that should be accompanied by an explanation as to why that question was being asked and why the answer was necessary. And I should just canvass that under the Queensland legislation, there's a clause, and the same in a number of other states, that says you can't ask a person a question, either orally or in writing, to supply information which might be, which unlawful discrimination might be based. So that's what they were saying that Woolworths was in breach of. They were asking a question or being asked to supply information on which unlawful discrimination might be based, i.e. age, gender. race. And so they said, all you need to do is say, are you over 18? Yes or no? And then provide that explanation. And then they said on the entitlements point, that information is, they say, clearly not necessary until the applicant has been at least offered a position, or perhaps you're discussing a potential position. So rather than just, logging your details into Woolworths, it's only at the point where you're being offered a position that your age might be relevant to those entitlements. And so they said that they thought that asking for the date of birth was not valid and was in breach of the legislation. On the gender point, again, Woolworths fell down because at that time, there was some assumptions made by Woolworths about the ways that they could gather gender information was basically by asking gender on the application process. And the tribunal again said, no, there's other ways that you can do that without insisting that it's a mandatory field that you fill out when making an application. And on the right to work, so again, they said they've had difficulty in seeing how it was justified that you insist that they upload documents which could contain confidential information like a birth certificate or passports or your visa. And again, you could simply ask to nominate whether they had the right to work in Australia. So ask that question, do you have the right to work in Australia? And then again, if there was a subsequent interview that was undertaken, then the people undertaking the interview might cite that documentation. And so that would again meet the requirements in terms of not having illegal workers within your organisation. So again, I just thought it was a really good example of kind of things that you might think, oh yeah, okay, Woolworths is saying, well, I need to know the date of birth to, distinguish between different employees and things like that. That thinking about, okay, what are the reasons that we're requiring this information, and is it in breach of that anti-discrimination legislation? And so, as I said, Woolworths has since changed their requirements, and most of those fields are now optional. And in this case, the prospective employee wasn't really able to establish what his loss was. Basically, he just said in his evidence that he was sickened beyond belief that Woolworths would disregard anti-discrimination laws. And so he didn't really produce any evidence of other positions he'd applied for and that he had lost any income by the actions of Woolworths. So he was awarded a nominal sum, a $5,000 amount for his hurt and humiliation. But again, I think it demonstrates things to think about in terms of recruitment and questions that we might be asking. As I mentioned, one of the things that I think is important is the use of recruiters, because I know a lot of organisations do use recruiters, and there's situations where we could be, as the organisation, liable for the comments made by recruiters. And that's because generally the recruiter will be said to be an agent of ours. So the statements were made on behalf of us, and the employee accepted the role on behalf of the statements made by the recruitment agency. So one thing I would encourage you to do is be very clear with your recruiters around what they can and can't say during job interviews, or to try to get people to come to work with you. We don't want them making promises that we can't keep, basically, or making statements that aren't true or are misleading. And so think about that in terms of maybe agree on some terms of reference or something like that with your recruiters around what they can and can't say for a particular role. Because most recruiters will be wanting to get the employee across, or prospective employee across, and probably say a lot of things to entice them. That's their job. And they might get carried away in terms of what they're saying. So we need to be clear with them in terms of what they can and can't say. And again, this is quite an old case, but again, a very good demonstration of when recruiters can get us into trouble. So in this case, the applicant, so the person who ended up bringing the claim, was a very senior executive, and he was recruited by a recruitment agency on behalf of Medical Benefits Fund. And he alleged that certain representations were made to him by both the recruiter in this case and some employees, particularly the HR employees of Medical Benefits Fund. And he says he was told that he would be provided with secure and long-term employment and that he would remain in the position for the long haul. And unfortunately, what happened is that after 2 years of employment, his employment was made redundant. So he was terminated by way of redundancy. And so he was saying that those representations were misleading and deceptive because I haven't been employed for the long haul and I haven't been able to secure long-term employment. And the court found that the recruiter and the organisation did engage in misleading or deceiving behaviour in terms of the longevity of the employment. And this was a particular concern for the applicant. So the employee in this case, he wasn't looking to move. And so he had been employed with his previous employer for over 12 years. And so this was a situation which the court described as executive headhunting. So basically, it wasn't like Mr. O'Neill was out there, you know, in the market looking for a job. He had been approached basically by the recruiter and they were trying to persuade him to abandon his current employment and accept this new job. So he was basically enticed away from his current secure employment, one that he'd been there for 12 years or over 12 years, to join this role. And so one of his concerns, which everyone agreed was pretty clear, was the longevity of the employment, because he was basically saying, look, I'm not really wanting to move and I've been here for 12 years. So I need to know that if I'm going to move, that it's going to be secure employment and I'm going to have that longevity of employment. Actually, in this case, what happened is the recruiter gave evidence on behalf of Mr. O'Neill. So he was one of their witnesses. And he says, yes, I did say these things to Mr. O'Neill, but, you know, it's like any other appointment. It's as secure as any job these days. And he didn't really have a grasp of what a contract meant. So one of the comments he made was, that he was appointed with no contract, and what he actually meant was it wasn't a contract for a particular period. So there was some comments that were potentially misleading around that as well. And the recruiter said, yes, I knew that the longevity of his employment was something that was very important to Mr. O'Neill, and that he says, but all of that stuff would have been worked out when he had the conversations with the employer. And that's not really my job. But unfortunately, what was found is that those statements that were made by the recruiter basically enticed Mr. O'Neill to move away from his employer and current employer and move to Medical Benefits Fund. And so the court said there was no doubt that at the time that they approached the applicant, he had no intention of leaving his secure employment. And that he was basically enticed away because of the statements that were made to him. And that they said that Mr. Ramsey, who was the recruiter in this case, was acting for and on behalf of the employer during the discussions, and that the applicant, Mr. O'Neill, had made him aware that he was concerned about leaving the position that he'd held for a significant period of time, and he was also concerned about the long-term nature of the employment. And he had expressed those sentiments, and that the comments that were made basically were misleading and deceptive about that longevity of employment. So just something to think about in terms of when we're engaging recruiters, how we're talking to them, making sure that we're being very prescriptive about what we want them to say or the requirements of the role, and that we don't want to be promising, you know, employment for 5 years or anything like that, because that can potentially raise issues and get us into trouble. Think about questions that we can ask during the recruitment or interview stage as well. So again, probably all of us here know, don't ask questions like, do you have any children, or are you pregnant? Do you have any health problems? Things like that. Probably not something that we need to be asking, because again, we need to think about it from those claims perspective that I was talking about earlier on, in terms of why are we asking that information? Is it relevant to the role? And so, but you can ask things like, okay, this role might require weekend or late nights. Is there any issues that you might have around performing that inherent requirement of the role? Or like I was talking about, if you need to do heavy lifting, do you have any difficulties in performing that work? And then kind of like the Woolworths case, then the question might be, are you at least 18 years of age in terms of the requirements of a particular role? So if you work at a pub or something like that, you need to be 18. So the question might be, are you at least 18 years of age? So it's not what is your age, it's a more general question than that. So we don't have to get an answer that says 21 or 25 or 17. It's just a more bland question than that. So really thinking about those questions. And as I said, I think that's a message that you really need to deliver to your managers that might be doing interviews and things like that, because they can kind of ask questions that they think are a non-event. They might just be making small talk, you know, during the initial phases of the interview that can then cause us issues later on. So if they're just saying in chit chat, or do you have any children? Like I said, if they then write that down, then that prospective employee might say, well, you didn't pick me because you don't think I can do the job because I've got children. I'm going to ask for flexible working arrangements or something like that. So I think the key message in terms of asking these questions and making sure that we're couching them in a manner that goes to the inherent requirements of the job. I'm also saying make sure that those people that are conducting the interviews are aware of these obligations, and that obviously, if something comes up in chit chat, so if someone offers that information, says, oh, yes, I've got 3 kids, very busy or whatever it is, that's fine. But again, don't write that down because it's not relevant to the role. So just make sure that it's not something that factors into your decision making when you're assessing a candidate for a particular role. This is an example of what not to do. And again, this was a case that was in the media a few years ago now, where this company Chevron had this particular application form, which, as you can see from the questions that are being asked on that form, are very intrusive and not likely to be relevant to a role that the employee was seeking to apply for. So things like, have you or your spouse ever been pregnant? And then can you list all the pregnancies, including any basically lost pregnancies, things like that. So again, generally not relevant to a particular role, and asking questions about health problems, things like that. As I said, there might be situations where it is an inherent requirement of the role that you can't have a back injury or something like that. That will go to inherent requirements of the role. The lesson in this case is basically this was an application form that was used overseas that they then adopted in Australia. And again, it's just being mindful of, you know, just taking something off the internet or using something from head office that's not based in Australia and then putting it out in Australia, and then we're in breach of anti-discrimination laws, or at least potentially in breach of anti-discrimination laws. Because whilst having this in the form might not necessarily breach anti-discrimination laws, although, like I said, if it's like a Woolworths case, then it potentially would be. But if the information that you collect in relation to these answers is then used in your decision-making process, that will definitely give rise to potentially a discrimination claim. The next thing I wanted to talk about was the use of social media in the recruitment process. So there's generally, like I said, people will get an application or something like that and might jump onto the internet, social media, and look up the person's information and have a look at their Facebook page or their LinkedIn page or all of those types of things. The caution that I would just say is be mindful of what then happens with that information, all of the obligations around privacy. So there's been a couple of cases, which I'll talk about in a second, that have basically said that you shouldn't just assume that information that's on Facebook is publicly available information you can do what you want with. There's some kind of limits around that. So just on this first slide, I'm talking about, obviously, if you go onto someone's Facebook page and you see they've got a particular sexual orientation, for example, or particular political allegiance, things like that, we don't want that knowledge to then be forming any part of a decision-making process in terms of who's the successful candidate for a job. So we don't want our managers, or if it's us conducting the interviews, thinking, oh, well, I see they've got 6 kids, we don't want anyone with children. Or I see their particular sexual orientation, we don't want that here. Things like that. And so the act of going on there and looking at that information can potentially put those things in our mind in terms of the knowledge that we have about that person. And so we need to be very clear, and that's where our documentation becomes very, very important. So we want to have clear, objective selection criteria for a role. So we can say, here's the selection criteria that we used. Here's everyone that applied. The reason the person didn't get the job is because this person was more qualified, or they didn't have this area of expertise, or we wanted 5 years experience and they only had 2, and we did have someone apply that had 5 years, so we went with them. It wasn't because of their sexual orientation, or it wasn't because of their gender, things like that. Also be mindful that if we're collecting any information, so if we're creating a record of that information, that there will again be those privacy obligations. So if we are collecting the information, the privacy legislation says that you need to take reasonable steps to tell the applicant that you're collecting the information. And also, as I mentioned earlier on, particularly if it's sensitive information, you generally need the consent to collect that information. So if you're creating a record, and for most of us, we're probably not going to be creating a record. It's not like we're going to be printing off the Facebook posts or anything like that. But again, it's just something to be mindful of in terms of those privacy obligations. And I think something you should filter down to those people who might get a resume and then, the first thing they do is jump onto the internet and look the person up, just reminding them of those obligations. This is the one I was touching on earlier in terms of, again, thinking about social media as a recruitment tool. And it was just something that was talked about a bit in the media, and I think does potentially raise some issues in terms of discrimination. And it's a bit similar to that case I was telling you about, where I had that employee who was trying to say you only had the job advertised online, and that's age discrimination. So what McDonald's did is they started to recruit through Snapchat. And basically what they created was a filter, and the person went on Snapchat and recorded a little video of themselves and why they want to work at McDonald's, and then that was given to McDonald's through the Snapchat application, and that was the first step in the recruitment process. And so one of the things that was raised in discussions was, is that potentially giving rise to age discrimination, because most Snapchat users apparently are between the age of 17 and 34, so I just miss out. And so in terms of thinking about what recruitment tools you are using, so that was very much directed to a younger workforce. And so thinking about, does that give rise to any issues that we might foresee in the future in terms of, for example, an employee saying, you're discriminating against me because I don't use Snapchat, and that's age discrimination. So thinking about the tools we might use. These are the 2 cases that I was talking about in terms of thinking about how we might use social media. This one wasn't during the recruitment phase, but I think it does give some indication as to how personal information that's available on Facebook and things like that might be used. This was a Victorian case, and it was about the Victorian privacy legislation. So I will just say that, but it does have similar provisions to what we see in the Commonwealth Privacy Act. But basically what happened in this case, the employee was investigated for misconduct because of what she had been posting on her Facebook about her work colleagues, including some abusive messages. And this was reported to the employer, and they engaged an external investigator to do the investigation. And what the employee said is that my personal information, including the Facebook messages, had been obtained without them first attempting to get the information directly from her. Because what the legislation says is you should try to get it from the employee first, or the individual first, unless that's not appropriate. And so they said, the tribunal said in this case, well, we don't agree with what you're saying, because the collection of that information was part of the investigation into your misconduct. And that you didn't hack into her Facebook or anything like that. And they said that the collection of the information was necessary for conducting the investigation and was for a legitimate purpose. And that if they had told her that they were intending on collecting the information, then she could have gone on and deleted it all. And then they have no information to conduct the investigation or put the allegations to her. So this was a case where they said that it wasn't appropriate initially to tell her up front that they were going to collect that information. So again, what I'm trying to establish here is that don't just assume that everything that's publicly available on Facebook is going to be something that we can use. And I just have this quote from the case which says, information that otherwise is personal might be accessible on some Facebook by anybody does not necessarily mean that the information is generally available publication. So equally, information that might be accessible somewhere on the internet does not necessarily mean that it's publicly available information. So again, I'm just saying be mindful of how we use social media and the information that we get from social media. This second case involved a organisation who basically was downloading images, facial images from a variety of sources, including, I believe, Facebook and things like that, of people's images. And so they call it scraping biometric information, so from the internet. So getting social media images and putting them into their website to create a facial recognition tool for generally government organisations to assess, criminals and things like that and see where they are in society. So in this case, they were found to have breached the Privacy Act because they were taking that biometric information from the internet and they had collected sensitive information. So facial recognition or images of faces falls into the category of sensitive information under the Privacy Act. And so they said that they had collected that information without consent. And what the Clearview tried to say in this case is, well, again, having it publicly available on Facebook means that you're giving implied consent. And the commissioner in this case said, no, we don't think that individuals would have been aware or had an expectation that the images had been collected. And you also didn't notify them, which is an obligation under the Privacy Act, that you had collected that personal information. And so again, it said that you can't just say, yes, you've consented because it's available on social media. So uploading an image to social media isn't necessarily consent to then using that image for whatever we want. So again, thinking about, not that I'm saying we'll download images of people and use it, but again, just the information, the point I'm trying to make is that the information available on social media, if you, again, collect that information or download it or use it in your decision-making process, just be mindful of the Privacy Act obligations as well, and just don't assume that it's all publicly available. So then this takes me to the decision-making process. So we've talked about, as we've gone through, making sure that we're not using these things that we might find on social media or asking discriminatory questions. So really we want to have a rigorous process and documentation around that recruitment process. So as I said, we want to make sure that the procedure we're applying for determining if someone's successful or not is applied across the board in the same manner. We're also giving appropriate weighting to each of the selection criteria. So the criteria that we're using and the inherent requirements of the role, or what we particularly want for that person to have, the desirable attributes, are very clear, and that we can say, well, this is why we picked this person, and this is why Jim or John or Judy didn't get the job, because they don't have these attributes that we need for the role, or they can't perform inherent requirements of the role. And we can establish that's the reason they didn't get the job, and it's not for any discriminatory reason. And obviously in the misleading and deceptive conduct, we want to have notes of what was said in the interviews. And so we can say, well, we didn't make any of those representations, they've made them up themselves, things like that. So our documentation is very important in that decision-making process. And we want to be able to make sure that our decision-making is justified in the circumstances. So what I would encourage you to do is, if you have concerns, particularly about managers making a particular decision in terms of a person, test them on that. Say, okay, why are we appointing this person? And make sure that we do have those sound reasons for appointing that person to a role and not another person. This is an example of a case where the employer was able to establish that the reason was not discriminatory. And it's, I think, a very good lesson in making sure we take contemporaneous notes of discussions that we have with prospective candidates about why they didn't get the job, things like that. So this was a case where the applicant was a man in his mid-50s, and he applied for a job as a lifeguard at a pool with YMCA. And the person who conducted the interview didn't recommend him for the position, and they didn't offer him a job. He made a claim saying that he had been discriminated against on the grounds of his sex and age. And he made that complaint because following him not getting the job, he had a discussion with an employee who wasn't in any way involved in the decision-making process about him getting a job. And they said, oh, you didn't get the job because you're a dinosaur. And so he then established that, okay, that's because of my sex and my age. And what YMCA said is that, no, we didn't discriminate against him based on his sex and age. We didn't give him the job because of comments that he made during the interview process. And that wasn't consistent with our policies and procedures, particularly because we do work with children. And so what he made comment about in the interview was that he said he basically has unorthodox methods to gain respect of the trust of youth. And he talked about in the interview that some children need to be touched and need to be wrestled. And, you know, you need to sometimes instill that in the children. And he says, I don't hurt them, but I do sometimes have to touch them or wrestle them to get them to trust me. And so obviously the employer had some concerns around those comments that were made. And they made very clear file notes of what was said, and then why they recommended that the person not be appointed to that role. When the person didn't get the role, he rang up the HR person and again questioned why they didn't employ him. And that person who had the conversation with him, the HR manager, again made a very detailed note of that conversation and said, you didn't get the job because these things were said in the interview and we have concerns around X, Y, and Z. It had nothing to do with your age or sex in terms of our decision-making process. And so what the tribunal said is that they accepted the content of that detailed contemporaneous record of the conversation, rather than general assertions that the prospective employee was making in his submission. So he had no evidence. He didn't keep a record of what he says happened in the interview or in those telephone conversations. But the employer did. So their employees were very good at documenting all of the reasons why that person didn't get the job. And they could establish, and the tribunal says, yes, we accept that contemporaneous file note. And that doesn't have to be writing it down. You can email yourself. You can do all sorts of things to make sure we've got that record of the conversation. But the key is to obviously being prepared, I think, for that conversation and saying these are the reasons you didn't get the job, because it's quite common for people to come back and say, why didn't I get the job? And if we can answer that honestly and say, here's the selection criteria we've used, this is why you didn't get the job, then that's a really easy one to kind of dispel any myths around it was because of someone's gender or age or things like that. And in this case, the tribunal relied on those contemporaneous file notes and records to say, no, you haven't been discriminated against. This case, I just wanted to touch on briefly to also make people aware that there are ways that you can recruit for particular roles. So in most of the state and federal legislation, you can apply for exemptions that would generally allow you to discriminate or engage in some form of discrimination. So this is an example where BlueScope Steel applied in Victoria for an exemption from the Victorian Equal Opportunity Act to allow it to prioritise female appointments at their Western Port manufacturing facility, including running some female-targeted, female-only advertisements. And they said that the exemption was to allow them to prioritise the recruitment of qualified female candidates over male candidates. And it came back to, okay, what was the objective of the Act? And that's to eliminate discrimination to the greatest possible extent. Now, it wasn't just a, yes, you can discriminate and choose females over males, because that generally won't be allowed by the Commission. What BlueScope showed is that they had tried to implement measures, so those less restrictive measures, to try to encourage females to apply for the roles, and that hadn't had the impact that they needed. So it hadn't worked in terms of increasing the participation of females. So they had like a diversity and inclusion plan, and they had a range of initiatives that they said was to attract more female employees, but they were still facing those challenges in terms of hiring and retaining the female employees. And so they said that they thought they needed a more proactive approach. But they also had to make clear that it wasn't like they were basically clear that they're saying we wouldn't just employ a person because they're female. What we really want the exemption for is to say, okay, if we've got a suitably qualified male and female, exact same qualifications, and we say they can do the role, that we can pick the female and not the male, which would generally be discrimination because we're picking it based on gender. They're not saying if that female didn't have the requirements for the role, we'll still pick her. They're saying everyone's suitably qualified and we want to be able to pick the female applicants and advertise specifically for female applicants. And so the Commission the Tribunal approved that exemption for a period of 5 years, I think it was, in that case, to allow them to specifically recruit. So there is, if you want to increase participation of a certain gender or things like that, there are ways that you can seek exemptions, like I said, under most legislation. And this was a step that BlueScope took in particular in their recruitment considerations. And the last case that I wanted to talk about before we finish up is, again, criminal records. So generally in most legislation, criminal records, so this was a complaint made to the Australian Human Rights Commission, and criminal records isn't a basis on which you can bring a claim. It just, what happens is the Australian Human Rights Commission can investigate that complaint. And basically what this employer did is found out basically a few weeks after commencing employment that this employee had a criminal conviction, and they terminated his employment upon finding out of that criminal conviction. And they said it was because he didn't have the values that they needed in terms of performing that role. And the Commission again said in this case, no, we think the actual reason was the criminal record. And he was assured at the beginning of his employment that it wasn't a condition of his employment. And then they said we can terminate during the probation period. It wasn't because of the criminal record. And the Commission in its investigation said, no, I think it's because of the criminal record and that you engaged in discrimination. Now, as I said, this situation, the employee can't bring a claim, so they can't bring a claim in the Commission or a tribunal. They can just bring a complaint, and what happens is that the Commission then makes recommendations about what they think should happen. So in this case, the Commission said, I think you should look at your policy. I think you should do some training around the inherent requirements of the job. So they said, I don't think not having a criminal record was an inherent requirement of the job, and so you've discriminated against the employee on the basis of that criminal record. And so you should do some training for your employees about discrimination. We want you to look at your policy. They also said, we think you should pay him an amount of compensation for his loss of earnings, i.e. losing his job, and also hurt humiliation. And in response to that, the employer said, we'll do the training and we'll look at our policies, but we're not going to pay any compensation to him because we were entitled to terminate his employment during probation. Now, that's not to say he might not bring another type of claim, but in terms of an actual discrimination claim, he was limited in terms of what he could do because the basis was a criminal record attribute, not something else. I've talked about these as we've gone through, but just remember that these are the risks that can give rise or can arise from these types of practices. So we've talked about a discrimination claim. A general protections claim is the same. So an employee might say, or a prospective employee might say, you've discriminated against me and haven't given me the job because of my age or my sex, things like that. So they could either choose to bring a general protections claim or a discrimination claim. They could bring an unfair dismissal claim. I think that's probably unlikely if they're saying it's because of a protected characteristic or because you've misled me in terms of what the employment will be. They'll generally bring a general protections claim or a discrimination claim for those protected attributes, and then a misleading and deceptive conduct claim under the Competition and Consumer Act for that misleading and deceptive conduct. And so they can get damages, as we saw in that O'Neill case, for those misleading and deceptive conduct, what their loss is for that. That's it in terms of what I had to cover. We're just on time, I think. Does anyone have any questions before we finish up? No? Well, hopefully that's given you some things to think about. Again, I think it's really important that you know about these things and it gives you food for thought, but also those people, because it's not necessarily always going to be yourselves who are doing those interviews or having those conversations. And also talking, if you do use recruiters, about what they can and can't say and being very clear about what they can and can't say. And then, yes, as Lisa just mentioned in the chat, thinking about social media and how we use that in our recruitment as well. Thank you all for joining me. I hope you have a good rest of the day, and I'll see you all at the next one.
Thanks, Erin.
Thanks, Erin.